Webinar put on by the Data Practices Office. My name is Grace Barron. I am a policy analyst with the Data Practices Office. And today we're going to be focusing on the open meeting law. I'll start off with a bit about our office. So what does the Data Practices Office do? We offer informal advice and technical assistance on the Data Practices Act and also the open meeting law. We also assist the Commissioner of Administration with issuing advisory opinions, and we're going to discuss some of the advisory opinions from the last year today. We also have a website and info pages that have a lot of resources, both on the Data Practices Act and the open meeting law. The links in the slide should work, and we also will have the slides available on our website as well. On the trainings page where you registered, there are slides at the bottom of that page. On our website, you can also sign up to be included on our listserv and to receive our newsletter. That will update you when we have new training opportunities coming up, and also update you about new advisory opinions and case law that comes out that involves Data Practices Act or the open meeting law. We also provide legislative assistance that would affect the Data Practices Act or the open meeting law, or that is somehow related to data. And we provide training like this one today. So this is today's agenda. We're going to go till about 11:45. As I kind of alluded to, we're going to start with a review of recent open meeting law advisory opinions. Then we're going to highlight questions that we've received in the past several months about the open meeting law. And then we'll wrap up with a Q&A session at the end of the webinar. You can send in your questions as you think of them, or you can wait until the end. Either is fine. You're going to submit those questions through the Q&A panel on Microsoft Teams. So that should appear on the top bar on your screen. There should be a Q&A that you can select, and it will open the Q&A panel. If you don't see the Q&A option, you may need to click the More button, which is displayed as 3 dots at the right-hand side of that panel at the top of your screen. If you select the More button, you should be able to open Q&A from there. So yeah, feel free to send your questions in now or at the end of the presentation. You do have the option to submit questions anonymously. I'll note that we do follow up with people after the webinar if we don't have time to get to all the questions. And if you submit your question anonymously, we won't know who you are. So if you do want follow-up, you will need to email us or call us, and then we'll be happy to get in touch with you and follow up on those questions. We do have several open meeting law resources available on our website. We have past open meeting law webinars available on YouTube. And we also have specific web pages on the website that focus on requirements for closing a meeting, requirements for providing notice, requirements around remote meetings, and then some myths and misconceptions about the open meeting law as well. This is a link to our advisory opinion library. We're going to be going over a few advisory opinions today, and you can search the opinion library by number, or you can search by a search term. We also have a glossary where you can select opinions by topic, so you can limit your search to open meeting law opinions. And I'll also have links in the slides to the specific opinions we're talking about, but if for some reason the links aren't working, you can feel free to go to that opinion library and search the number, and it'll pop right up for you. All right. So we're going to go ahead and get started talking about open meeting law advisory opinions from the past year. So our first advisory opinion is 25-010. And in this case, a private group of residents hosted an invite-only event about an upcoming school board referendum. They sent invitations to this event out to people they wanted to invite, and those invitations said that the superintendent and school board members would be present at the meeting. At the event, the superintendent discussed school funding and plans for improvements and changes to the district. A presenter discussed curriculum opportunities, and a board member provided information on voting for the related school bond. At this event, the board chair and 3 other board members were present, and this school board had a total of 7 members. So the issue that the commissioner considered was whether the school board complied with the open meeting law when members of the board attended this event. And the commissioner opined that the school board did not comply with the open meeting law. In Moberg versus Independent School District number 281, the Minnesota Supreme Court set out the test for determining whether a gathering is subject to the open meeting law. And that's our first bullet point here. So a gathering is subject to the open meeting law if a quorum or more of public body members are present and those members discuss, decide, or receive information related to the official business of that public body. In the opinion, the commissioner noted that there's no intent or formal action requirement. So the members don't have to intend that they're holding a meeting, and they don't have to take any formal action on business. If they're discussing, deciding, or receiving information related to the official business and there's a quorum of that public body present, then it is going to be a meeting under the open meeting law. While chance or social gatherings are not subject to the requirements of the open meeting law, Moberg, that Minnesota Supreme Court case, held that a quorum may not, as a group, discuss or receive information on official business in any setting under the guise of a private social gathering. So you can't have a quorum of a public body discussing or receiving information related to their official business and say that, oh no, this is a social private event, and so it doesn't count as a meeting. That is not an out from the open meeting law. So in this case, 4 of the 7 board members attended the event, which meant that there were a quorum of board members present, and the quorum received information related to the official business of the board. The discussion of the school curriculum and the school bond were all directly related to the school board's business. Next up, Advisory Opinion 25-008. In this case, a city council held an emergency meeting to approve a wastewater services contract. At this meeting, 1 member abstained, and the remaining members voted to approve the contract with MMS Environmental to perform regular wastewater services for 3 years. So the issue that the commissioner considered was whether the city council complied with the open meeting law when they had an emergency meeting to consider a contract. And the commissioner opined that the city council did not comply with the open meeting law. So the analysis that gets to this conclusion looks like this. One of the mechanisms to ensure that a public body's meetings are open to the public is to provide appropriate notice of meetings. Notice of emergency meetings is limited because these meetings are held to address issues that require immediate consideration by the public body. And that's set out in Minnesota Statutes Section 13D.04, Subdivision 3. Emergency meetings should be held in rare circumstances where public safety is at risk, and meeting the 3-day notice requirement for a special meeting is not possible. So given the definition of emergency meeting in Section 13D.04, the subject matter of an emergency meeting is such that you can't wait 3 days to take action that needs to be taken. Additionally, the commissioner has previously stated that public bodies should hold emergency meetings only in rare circumstances where public safety is at risk. In this case, the minutes of the meeting did not indicate any sort of public safety concern that required immediate action. The minutes only indicated that the council wished to sign the contract for regular wastewater services to comply with other state law requirements quickly. So it didn't appear that this was an emergency issue, right? They wanted to comply with the law and they wanted to have a regular contract in place, but there wasn't any sort of public safety emergency that this needed to happen that day versus 4 days later. Okay, Advisory Opinion 25-002. Here we had a County Board of Commissioners, the board, and they held a regularly scheduled meeting at the County Government Center starting at 8:30 a.m. Afterwards, all of the commissioners then went to tour a county-owned building with potential tenants to explore options for a new childcare center. Neither the regular meeting notice nor the agenda mentioned the scheduled tour, and a recording of the regular meeting did not mention the tour, and the recording actually stated that the meeting was adjourned. The draft regular meeting minutes did not originally mention the tour, but were later corrected to document that the regular meeting was recessed and would continue at the tour location. So the issue the commissioner considered was whether the board complied with the open meeting law when commissioners gathered to tour the county-owned building after the board's regular meeting. In this case, the commissioner could not determine whether the board complied with the open meeting law due to a factual dispute. So here we had a member of the public who attended the meeting remotely who argued that the board adjourned the meeting. And as I discussed, the recording said that the meeting was adjourned. But the board said that a county employee stopped the recording after the chair's comment that the meeting was adjourned, and therefore the recording did not show that the county administrator promptly corrected that statement and instead added that the meeting was adjourned and that the board was recessing the meeting. The county administrator said that the board would immediately reconvene the meeting at the county-owned building and gave the building's location. So under Minnesota statute section 13D.04 subdivision 4A, if a meeting is recessed or continued, if a meeting is a recessed or continued session of a previous meeting, and the time and place of the meeting was established during the previous meeting and recorded in the minutes of that meeting, then no further published or mailed notice is necessary. So that means that if the board adjourned the meeting, then the board members' special meeting with potential tenants to tour the county-owned building violated the open meeting law. If the meeting was over, then this would have been a special meeting that occurred without notice, and so it did not comply with open meeting law. However, if the board recessed the meeting and announced the time and place of the tour before recessing the regular meeting, and then the tour was actually the board members reconvening the regular meeting at the tour location, then that did not violate the open meeting law. As I noted previously, the regular meeting minutes did not originally reflect that the board recessed the meeting, but the meeting minutes were updated after the fact to state that the regular meeting was recessed and would continue at the tour location. As you can see, we had a factual dispute here as to whether the meeting was actually adjourned or recessed, and the commissioner noted the importance of keeping accurate records. So while meeting minutes are not actually required by the open meeting law, many entities do create and maintain such minutes in order to meet the requirements of the Official Records Act. When government makes records of its official activities, those records need to be accurate. So here, if the meeting minutes were accurate from the beginning, that would have gone a long way to support the board's argument that the meeting was actually recessed and then reconvened at the tour location. All right, our last open meeting law advisory opinion for the day is 25-001. On December 12th, 2024, a Township Board of Supervisors, the board, held a special meeting to interview candidates for an open supervisor position. During the interviews, the two supervisors and the town clerk filled out score sheets for each candidate. These scoring sheets were sealed and provided to the town clerk at the end of the interviews. Before the next meeting, the town clerk and the town treasurer opened each of the envelopes and tallied the results. At the board's next meeting on January 9th, 2025, the individual who received the highest score from the scoring sheets was present, and they were appointed to fill the vacancy. This appointment was done by a public vote. So the issue was whether the board complied with the open meeting law when it made a final decision on appointing a new board supervisor outside of an open meeting. And the commissioner opined that the Board of Supervisors did not comply with open meeting law. Appointing a new supervisor when a position becomes vacant was part of the board's official business, and the board chose a process where candidates would be interviewed and evaluated at a meeting. Minnesota Statute Section 13D.01, Subdivision 4A, says that the votes of the members of the board on an action taken in a meeting required by this section to be open to the public must be recorded in a journal or minutes. And no exception to close the meeting applied in this case. Here, although the appointment happened at an open meeting on January 9th, the selection of the candidate happened outside an open meeting. The score sheets themselves determined who would be appointed to the position, and therefore the selection of the candidate happened when those score sheets were tallied. And that happened sometime between the December 12th meeting and the January 9th meeting. Votes conducted during an open meeting must be done in public and recorded in the minutes or journal of votes. Otherwise, members of the public who attend a meeting cannot understand how individual members of a public body voted on a particular issue, and the meeting is not really open under the open meeting law. Even though the appointment of the new supervisor happened at that January 9th meeting, the selection of the individual occurred outside an open meeting when the score sheets were tallied. It's not enough that the score sheets were available after the fact. The obligation to have a public vote and for that vote to be public in the meeting remains. So here the score sheets communicated the vote of each supervisor and were required to be public at the December 12th open meeting when those votes were made. All right, so that's it for our open meeting law advisory opinions from the last year. I'm happy to talk about any of those further with you. If you have questions, you can reach us by phone or email, which I will share at the end if you don't already have our contact info. But now we're going to go into our open meeting law potpourri. So these are some common questions about the open meeting law that we receive that I think would be helpful for everybody to have a glance at. So first we have a question about remote attendance and camera settings for local public bodies. And the question is, are local public body members required to have their cameras on when they attend meetings remotely? The answer is yes. When local public body members attend meetings remotely, they are required to have their cameras on. And this is the analysis to how we get there, right? So under Minnesota Statute Section 13D.02, Subdivision 1, local level public bodies may conduct meetings by interactive technology so long as the specified conditions are met. Section 13D.02, Subdivision 1.1 requires that all members of the public body participating in the meeting, wherever their physical location, can hear and see one another. The open meeting law also provides a definition for interactive technology in 13D.001, Subdivision 2. And that says that interactive technology means a device, software program, or other application that allows individuals in different physical locations to see and hear one another. So since there's this requirement that members can hear and see one another, members are required to be on camera if they are attending the meeting remotely. All right, so now we have the same question, but the public body is a state level public body. So are state level public body members required to have their cameras on when they attend meetings remotely? Here the answer is no. So there's not the same on-camera requirement for state level public body members who attend meetings remotely. The requirements for state level public body members conducting meetings remotely are set out in 13D.015. And that says that state level public bodies may conduct meetings by telephone or interactive technology so long as the specified conditions are met. 13D.015 Subdivision 2 requires that all members of the entity participating in the meeting, wherever their physical location, can hear one another. So there's not this requirement that they can hear and see one another. For state level public bodies, the requirement is only that the members can hear one another. Therefore, they do not have to be on camera when attending the meetings remotely. All right, question 3. Reasons to participate remotely. Can a county board member participate in a board meeting from a location outside of the United States? The answer is yes. And we have our little astronaut here attending the meeting from somewhere in the galaxy, and that would be acceptable under the open meeting law. So, public body members can participate in meetings remotely for any reason as long as statutory requirements are met. And there's no limitations as to where a public body member can be located when attending a meeting remotely. Section 13D.02 sets out the requirements for local public body members to participate in meetings remotely. This section was recently amended to allow members of local public bodies, including county commissions, to attend meetings from remote locations at any time for any reason. Additionally, the locations where members are attending remotely from no longer need to be open to the public, and public bodies no longer need to notice the locations that members will be participating remotely from. However, subdivision 6 in section 13D.02 remains in the statute, and subdivision 6 requires the meeting minutes to reflect the names of any members who appear by interactive technology and to state the reasons for the appearance by interactive technology. So even though members can appear remotely for any reason, that reason still needs to be documented. There's not really guidance on how specific the reason needs to be, but really it should be whatever the public body member gives as their reason for participating remotely. So this might be for convenience. They might share that they are sick and so they're choosing to participate remotely, or maybe they'll say they're traveling. Whatever reason the public body member gives, that needs to be documented in the meeting minutes. I'll also note that the requirements for state-level public bodies are set out in 13D.015. And similarly, there's no limitations as to where a public body member can be located when attending a meeting remotely. However, 13D.015 does not have the same meeting minutes requirement. So for state public bodies, they do not have to have the minutes reflect the reason that they are appearing remotely. Question 4, live video feed. So are public bodies required to provide a live video feed for members of the public to remotely view open meetings? The answer is that if members are participating remotely, the entity, to the extent practical, shall allow a person to monitor the meeting electronically from a remote location. This is set out in 13D.015 and 13D.02. So this requirement applies to both local level public bodies and state level public bodies. The question becomes, what is the extent practical and what is allowing a person to monitor the meeting electronically? If the entity is able to accommodate members participating remotely, it's likely practical to meet this requirement. If you are allowing members to join via a link, there's probably a way for you to share a public link as well. But this requirement doesn't necessarily require a live video link. You could provide a video link or you could do a call-in phone number. There has to be some way for a member of the public to monitor the meeting from a remote location. I will note, if all members are physically present at the meeting location, this requirement does not apply. So this only applies where members are participating remotely. If all of the members are there, nobody's participating remotely, then there's no requirement to have a link or to have a call-in phone number for members of the public to participate remotely. All right. Question number 5, members of the public live streaming. Do we need to allow members of the public who attend meetings to live stream the meetings on their phones? Here we have a member of the public, they've got their phone up, they're recording the board as they speak. Is this something we have to allow? The answer is probably, as long as the member of the public is not being disruptive when they are recording. The open meeting law itself is actually silent as to whether members of the public can record or live stream an open meeting. However, a 1972 opinion from the Attorney General's office concluded that members of the press, who are also members of the public, could record the open meetings of a city council as long as the recording was not disruptive to the meeting. So we believe that this analysis extends to live streaming as well, whether they're live streaming or recording the meeting, as long as members of the public are not being disruptive, not making it so that the meeting can't continue to take place. If someone is just passively recording the meeting or live streaming the meeting, that's going to be allowed under the open meeting law. All right. So we are going to start getting to questions today from you guys. I'm also going to share an evaluation in the Q&A panel. If you could fill that out, we would greatly appreciate it. I will do that now. As I mentioned before, if we don't get to your question, we will follow up with you afterwards. However, if you do choose to post anonymously, we don't have a way to follow up with you, so you will need to reach out to us if you would like us to follow up with you. The slides are available on our trainings website on the webinars page. If you scroll down to the bottom, there are slides from past webinars, and this is under the OML webinars. A recording of this webinar will also be available on our YouTube page. And yeah, we really appreciate if you could fill out that evaluation. It helps us as we plan for the future.
Okay, so yeah, we'll go ahead and get started on the questions. Just as a note here, if there is some silence or you, you don't hear anything for a few minutes, your computer's probably still working in most situations. We're just simply reviewing the questions and making sure that we understand everything before we just start answering. So just keep that in mind. So we'll just start with the first question here that we have. If an open meeting will be offered in a hybrid format, in person and remote, then is it required to share, provide public notice, how to participate both in person and remote formats? Grace got to this a little bit in question 4. And so again, I'm not sure when we're talking about hybrid format, if we're talking about, all members being in person and then you're live streaming, or some of the members of the public body are attending remotely. So again, if all members are in person, then those requirements related to 13D.015 and 13D.02 are not required to be followed. So, whatever process your public body has in place to live stream a meeting when all members are in attendance in person, that's outside of the open meeting law, and whatever process you're using to live stream that should probably be reasonable, and take that approach. Now, if you have members who are attending remotely, then yes, I think there are some obligations to share or provide some notice how members of the public can participate in the meeting, or view the meeting, review the meeting, or excuse me, I think the language is monitor the meeting electronically. And so that requirement is in 13D.015 for state level public bodies, as well as 13D.02 for local public bodies. And both of those sections do have some notice requirements. And so when you're noticing to the public that some members are going to be attending remotely, that would also be the opportunity to inform members of the public how they can monitor the meeting remotely also. What that process is really going to depend on your public body and how you want to do that, whether it's just providing a link to the meeting, like a Teams meeting or a WebEx meeting or whatever platform you use to host your open meetings remotely. I think that's one way to do it. I know other government entities or other public bodies have, put a notice in there that says, please contact this individual for a link to our meeting, and then that individual follows up with a link to the meeting. That's also fine, so long as you're making sure that you're providing that link and allowing people into the meeting. That is all appropriate processes. But yes, high level answer here, you are required to share or provide some sort of notice how individuals can monitor that meeting remotely, based on that language of the fact that you have to notice that some members will be attending remotely. So all of that information should be in that notice.
Great. I can hop into the next question. So the next question we have is, if there are significant short-term public safety concerns, are we required to offer an in-person meeting, or can it just be online? Thank you for that question. That's an interesting question. So the two avenues to offer online meetings, or meetings conducted by interactive technology, remote meetings, are found in Minnesota statutes 13D.015 and 13D.02. And which avenue, which statute you're using depends on what kind of public body you are, right? So those would be the two avenues that you would look to have a remote meeting. And there are requirements in each of those statutes, and both of them, both avenues. So regardless of what type of public body you are, you do have a, original in-person meeting location, your usual meeting room, right? It still has to be open to the public, and one member of the public body does have to be in that meeting room. So when we're talking about the open meeting law requirements for these online meetings, most of the members could potentially be remote and attending this meeting remotely, but one member does have to be in that regular meeting location in that room that is open to the public. So here the question is, what if there are other concerns, right? What if there are public safety concerns, and it's not safe to have that physical location open at that time? And sort of our response is the open meeting law doesn't contemplate this. There is not an avenue in 13D that says, if it meets this threshold, then you can, conduct your meeting completely remotely under the two current avenues. So I would say if you have those considerations, there are other considerations outside of Chapter 13D that may play into how your public body conducts its meetings. So I would just encourage you to chat with your legal counsel and perform that risk assessment and see what other things you have to consider when it comes to how you will be conducting your meeting and what your risk tolerance is for going a little skew from the 13D requirements. So I hope that information is helpful.
And I'll just piggyback on that just a little bit. And in addition to talking with legal counsel, certainly reach out to local law enforcement or kind of other public safety contacts that you have in the area who may be able to offer some guidance in additionally to that. Or if you're at the state level, certainly and near the Capitol complex, certainly reach out to Capitol Security or the Department of Public Safety and see what they may be able to offer there for you too. But agree on everything Ellen just said there. And so, all right, the next question here. When the reason to appear remotely is illness, are there any concerns about violating the Data Practices Act by putting this in the minutes? It's a good question. It actually raises a lot of additional questions about what type of public body this might be, whether the members of the public body are elected officials or appointed officials. And things like that, because elected officials aren't automatically covered as employees for personnel purposes under Section 1343. A government entity would need to make that affirmative determination that they are. So what I'll say is this, is that I think simply providing information that someone is ill and attending remotely probably doesn't violate any Data Practices Act data protections, or the fact that it's probably not private data. And I would just simply point to under 1343 subdivision 2, the payroll timesheets or other comparable data that are used to account for an employee's work time, that is public data, except for the extent for the employee's reasons for the use of sick time or other medical leave. And so if you provide an in-depth reason why somebody might be ill, that could potentially raise some concerns. But I think just the fact alone to meet those requirements that somebody is attending remotely due to illness probably is high enough level that it isn't creating any Data Practices Act concerns. And then on the flip side, you're also meeting your obligations under 13D. So yeah, I think keep it at a high level and not go into any sort of depth would be sufficient in order to meet your 13D requirements.
Great. I will hop to the next one. So our next question is, if a member is attending a state public body meeting from remotely and a vote is required, what are the roll call requirements, if any? Great, thank you for your question. So if this is a member attending a state public body meeting remotely, we are looking at the requirements in Minnesota Statutes 13D.015 to communicate what requirements are there. And under subdivision 2(4), all votes are required to be conducted by roll call so that each member's vote on each issue can be identified and recorded. So we have to know who is voting what, right? So that roll call vote is required. And again, for public body or state entity meetings, excuse me, under 13D.015, there is an audio requirement here, right? All members, regardless of the location, can hear one another and hear all discussion testimony, so that audio roll call vote is required for a state public body meeting for the members. Hope that assists.
Okay, the next question. Can a mayor interview council member candidates, and when he makes his choice, can he then announce his choice at a council meeting? Note, there was a council member who left during his term. Our ordinance does address that the mayor may appoint. Good question. So again, I'm not sure how this entire maybe public body operates. There are some strong mayor systems where the mayor is independent and doesn't sit on a city council, or there are some other situations where the mayor is on the city council and it just happens to be the first among equals. So, the facts matter here. But what I think we can get to on this point is going back to that Moberg definition of what is a meeting for the purposes of the open meeting law, and what is, when folks are gathering, when are they needing to have those meetings be open to the public? So just as a reminder, Moberg says that a meeting, and when the open meeting law requirements apply to a gathering of a quorum or more of a public body's members when they discuss, decide, or receive information related to their official business. And so if it's just a single, if the process that is set up for your council is that the mayor can meet with candidates on his own and then simply appoint a member of that, appoint a member or a new council member to the city council, then I think it seems unlikely to me that the mayor alone is a quorum of the public body of the full city council. Again, I might be wrong there, but in this situation, I think the mayor is probably just one person. And so, simply meeting or interviewing potential candidates so the mayor can appoint another person to the council probably doesn't meet the definition of meeting under the Moberg case. But if it's a really unusual situation where you think the mayor alone might be a quorum, it seems unlikely, reach out to our office and we can certainly discuss further. But in this situation, I don't think there's any open meeting law requirements for the mayor when meeting with potential city council members, to appoint that person if the mayor is granted that power on his own.
Okay, next question. Sorry, I just have to bring it up again. We had a couple questions on this theme, so hopefully the answer to this one will assist you all. But this question is, for an advisory council that is supported by the state and having a remote meeting, can a state staff member who supports the meeting be considered the body member in the room? So this is a question about kind of the language in 13D.015, which is what guides us for how to conduct a meeting using interactive technology for a state level public body. And one of the requirements, again, is that a member of the entity be physically present at the regular meeting location that's open to the public. So what's interesting in this language versus the language for other public bodies, in 13D.02, it says a member of the body has to be physically present in the regular meeting location. And here it's a member of the entity. So we do get this question frequently. Can it just be a staff member? Does it have to actually be a member of the body? And so our guidance, our guidance, and I know in the past the Attorney General's office has provided guidance that really that member of the entity that has to be physically present in that meeting or for a state level public body should be a body member, a voting member of that public body. If you look at 13D.015, it really is using that language entity to indicate the public body. So we do think it should be one member of the public body that needs to be physically present in the regular meeting location. But again, that is ultimately your call and your legal counsel's call on who is the appropriate person to be in that room. But I hope that assists.
Okay, the next question here. How do the requirements to see and hear others remotely and interact apply when there are requests for reasonable accommodations for members or staff with disabilities? And under Title I, I'm assuming of the American Disabilities Act, and reasonable modifications for the public, Title II. The current citations don't address the use of information and communication technology where accessibility ensures people with physical, sensory, or cognitive disabilities have equal access. I think this is a really great question, and I agree the open meeting law doesn't contemplate these sorts of situations where you might have members of the public body who have some sort of disability that require accommodations or some other considerations for how they should be able to participate in the meeting. And so I guess as a very tight reading of the open meeting law, there might be some technical violations. That said, the open meeting law is just one law in the consideration of things, right? There's other laws that we've got, the state human rights, Minnesota Human Rights Act. We've got the ADA, the Americans with Disabilities Act. That's a federal law. Those other considerations do come into play. And so I would just remind folks that, the open meeting law isn't always necessarily the most important law, especially when we come to these sorts of reasonable accommodations. And so there may be a need to offer some reasonable accommodations for members of the public body if they happen to use sign language because they don't hear, or they may be blind and so they can only hear, those types of things. There are reasonable accommodations that can be put into place for those folks, and I don't think it would be a violation of the open meeting law to offer those accommodations because those other laws do apply. So when you have questions about that, or you receive requests for reasonable modifications or accommodations, certainly reach out to legal counsel or to the staff at your entity who handle those ADA considerations, and work with them to make sure that you are providing reasonable accommodations. Because again, I think those other laws still apply in addition to the open meeting law. And so the open meeting law doesn't supersede any of those other requirements that you're obligated to meet under the Human Rights Act or the ADA.
Okay, we had another question about votes. I'm just finding it again. Apologies. Okay, related to the roll call requirements, are names and votes required in the minutes? Thank you for that question. So to talk about what's required in the minutes, I'm going to look at Minnesota Statutes 13D.01, and Subdivision 4 talks about what votes are required to be documented either in the Journal of Votes or the meeting minutes, however you're documenting your public body's work. So it says the votes of members of the state agency, board, commissioner, department, or of the governing body, and so on and so forth, on an action taken in a meeting required by the section to be open to the public must be recorded in journal or minutes. But then B says the vote of each member must be recorded on each appropriation of money except for payments of judgments, claims, and amounts fixed by statute. So that's kind of two interesting provisions. Explicitly, the vote of each member does have to be recorded in the journal of votes or the meeting minutes for those appropriations of money. But then the votes of the members are also required to be documented. I would say it is best practice to record the names and votes for all of the votes given these meeting and journal requirements in 13D.01. So I would take a look at that language and see how you feel about it when it comes to documenting those votes, but I would record those names and votes in your meeting minutes.
Okay, I think this might be the last question we're able to get to this morning. But again, if you have additional questions, you can certainly email our office directly, and we're happy to answer those questions. And so this last one here, regarding the vote during municipal government meetings, including councils and commissions, is there a statute that requires an explanation within the minutes that provides a summary for a nay vote or an abstention vote? Short answer is Maybe. I'm not sure. I don't think our office has a good answer to that question, mostly because we're experts on the open meeting law, Chapter 13D, and there's no requirement in 13D that meeting minutes must be created or that they need to document certain things, such as the reason for a nay vote or an abstention vote. That said, there may be other statutory sections that apply to city councils or school boards or county commissions that may have some sort of requirement like that, and we just maybe aren't knowledgeable about that. So my suggestion, maybe reach out to the good folks over at the League of Minnesota Cities or your other association that helps offer some guidance about kind of the enabling legislation as it relates to cities or whatever public body you're with, and ask them that question. They might be aware or might have some information about whether or not those requirements exist in other statutory sections.
Thanks, Casey and Ellen. So yeah, we are at time for today. I know that there were quite a few anonymous questions posted in the Q&A panel. Like I said, if you would like us to follow up with you on those questions, if you could shoot us an email at info.dpo@state.mn.us, we'd be happy to get back to you. Or you can also always call us and leave a voicemail. We can return your call and talk about things over the phone. That's our office phone number there, 651-296-6733. That's it for today, though. For people who did ask questions and have their names attached, we will be able to follow up with you because I have your email. So look forward to an email from us, and thank you all so much for joining, and we'll be in touch.